Welcome to today's Big Talk. Today we have a very special panel with us. I'd like to introduce the first panel with the moderator, Ms. So Jing Han. Ms. So Jing Han read law at the University of Malaya. She was admitted as an advocate and solicitor of the High Court of Malaya in 2013. Thereafter, she joined Osman Davidson & Co. in 2013 and left the firm in 2021 to set up HL Wong So & Co. as one of its partners. Ms. Jing Han is a dispute resolution lawyer specializing in construction and commercial claims. She has represented employers, main contractors, and subcontractors in court litigation, arbitration, and adjudication proceedings. She has also been involved in various commercial disputes, including shareholders and directors disputes, minority oppression claims, and tortious claims. Ms. Jing Han's practice areas also include advisory works and the drafting of various construction-related contracts. Mr. Wong Hin Loong, our first speaker, Mr. Wong, was admitted as an advocate and solicitor of the High Court of Malaya in 2000. He is a fellow of the Chartered Institute of Arbitrators CR, the Singapore Institute of Arbitrators CR, and the Malaysian Institute of Arbitrators MIAR. He has more than 24 years experience as counsel in litigation, arbitration, and adjudication proceedings. His area of practice primarily revolves around construction law, civil and commercial disputes. He was formerly a partner for 15 years in a mid-sized, well-known legal firm in Kuala Lumpur, which specializes in civil litigation, construction arbitration, and adjudication. He was the co-head of the dispute resolution team, and in 2021, he established his own firm, HL Wong So & Co., with another partner, Ms. So Jing Han. He is currently impaneled as an arbitrator with BicTok. Ms. Karen Ng was admitted as an advocate and solicitor of the High Court of Malaya in 2000. Ms. Karen Ng's areas of work to date include advisory work, litigation, arbitration, and adjudication in the fields of construction law, oil and gas law, contract law, and company law. Her focus is construction law. She has vast experience in drafting and reviewing various construction-related contracts, joint venture, collaboration agreements, consultancy agreements, and oil and gas-related contracts. She was formerly a partner for 6 years in a mid-sized, well-known legal firm in Kuala Lumpur. And in 2021, she established her own firm, Yatiswara Ang Chan, with two other partners, Mr. Yatiswara Ramachandran and Mr. Kenny Chan Yu Hung. She is a RICS accredited evaluative mediator and is currently impaneled as a mediator with the AIC. Mr. Goh Chin graduated from University of Malaya with a Bachelor of Laws in 2012 and was called to the Malaysian bar and admitted as an advocate and solicitor of Malaya in July 2013. His experience includes advising and acting in a wide range of matters such as construction arbitration, construction adjudication, litigation, both construction and general, and commercial contracts advisory. All of our panelists today are impaneled adjudicators with the AIC, and without further ado, I will pass the floor to our moderator for today, Ms. So. The floor is yours.
Thank you, Sharifah. Good evening, everyone. My name is So Jing Han, and I will be the moderator for this talk. We have 3 speakers with us today. Each speaker will have a total of 15 minutes for their presentation. After all the speakers have finished their presentations, we will have a question and answer session for 15 minutes. If you have any questions for the speakers, please feel free to use the chat feature to ask your questions, and I will read your question out. Mr. Wong, I think you may start now for your question.
Yes, thank you very much, Jing Han. So I would have prepared some very brief slides for my presentation. Just give me a moment so to share the screen. Okay. Can you see on the screen?
Yes.
Okay, so we just start off with, as far as the topic is concerned, we are looking at what are the damages that a contractor can be liable for non-completion of works. So in general, the type of damages the employer can claim, as we know, is of course, firstly, repossession of the site. Secondly, the most common one is the liquidated damages or the liquidated ascertained damages. And then of course, they can also claim for defective works. Then the additional cost to complete the remaining works. The call on the performance bond, again, a very common area. Nowadays, for most construction contracts, you have the performance bond or bank guarantees, which is payable on demand. And lastly, of course, the employers can also claim for loss of profit. So I just want to talk a bit more about the common claims, which is the liquidated ascertained damages. Before that, we can look at, as we know, when we talk about liquidated damages, that is found under Section 75 of the Contracts Act, and of course, the well-known cubic electronics case, which says that as far as the innocent party is concerned, once you have a LAD clause, you can claim the amount stipulated in the LAD clause, irrespective or not actual damage or loss is proven. And then the defaulting party, which will be the main contractor, has to show that this agreed predetermined sum is unreasonable in proportion to the likely or actual damage suffered. So this is all tried law, Section 75, cubic electronics. I shall not spend so much time on them. Now let's look at the actual practice. In actual practice, how does the employer enforce a LAD clause? Of course, the employer can actually enforce the LAD clause. Firstly, it goes without saying that there must actually be a LAD clause in the contract, and there must be a date of completion in the LAD clause, which is actually stated, because you need a date when the employer can start calculating the date when the LAD would actually commence. Let's say 10,000 ringgit for each day of the day, which could be from the date of completion, let's say, is from the 1st of January 2025. So there's a definite date in which the employer can calculate the LAD. And then we also must have an EOT clause, extension of time clause, because if we don't have the EOT clause, that the general principle is that time is set at large, and the main contractor is only obliged to complete the works within a reasonable time. So this means that if there was an act of prevention by the employer, for example, late issuance of drawings, late instructions, issues regarding late site possession, then there must actually be a EOT clause in the contract so that the contractor, because of the act of prevention by the employer, he can apply for EOT, and the employer or the SO, after assessing it, they will grant the EOT. So if there is no EOT clause, then the employer cannot actually claim for the LAD. And this is again, very tried principle. We have the RC Asia Engineering case. If you don't have the EOT clause, then the employer can only prove general damages or claim general damages, which is, of course, the actual special damages which have actually suffered. So everybody knows that you must actually have an EOT clause in order to enforce a LAD provision. But as we know, recently there has been some development in the law, which is in the Era Kemuncak Jaya case. Now, the Era Kemuncak Jaya case, which was decided by Justice K.K. Wong, he actually held that the employer of a construction contract has an implied contractual right to give an extension of time to a contractor when the contract is silent on EOT. And there's no requirement for the contractor to apply for EOT before the employer's implied right can be exercised. This is because even if the contractor has not applied for EOT, the employer's implied right can still be exercised as the employer sees fit. Now, the Era Kemuncak case perhaps can be understood because in that case, although there was no EOT clause, the contractor have actually applied for 4 EOTs, which was actually assessed and granted by the employer. So based on that situation of the case, the Learned High Court judge said, look, there is actually a new completion date that has actually been fixed, notwithstanding the fact that there is no EOT clause. Therefore, the LAD clause is still enforceable. And in the recent Masumira case, the same issue again happened. The High Court took the traditional approach, followed the decision in RC Asia Engineering, declined to follow the approach in Era Kemuncak. Similarly, in Masurimas, the contractor, upon the employer's request, have actually applied for numerous EOTs. There was actually no EOT provisions in the letter of award, but the employer have actually assessed the EOTs and actually granted the EOTs. Notwithstanding that, the Learned High Court judge in Masurimas said the traditional approach in RC Asia is still correct. time for completion is set at large because there's no EOT clause, and the LAD clause here is unenforceable. Now, the case of Masur Rimas against Dorset is now pending determination at the Court of Appeal. Both the plaintiff and defendant have appealed to the Court of Appeal, and we will have to see how these matters would actually be decided by the Court of Appeal. To my mind, the case of RC Asia and the case of Era Kemuncak can be reconciled in a situation where even if there is no EOT clause, but the employer have actually assessed the contractor's EOT applications and granted a new completion date, then in that situation, I think the LAD clause should still be enforceable. But we shall see how the Court of Appeal will decide in the case of Masur Rimas against Dorset. The other things to enforce the LAD clause is, of course, the issuance of CNC, could be under the PAM contract or the IAM contract, for example. So the architect has to issue a certificate of CNC, giving formal notice to the contractor that they failed to complete the works by the completion date that was last agreed. So in some of the contracts, for example, PAM or IAM, for example, the issuance of a CNC is a legally conditioned precedent before the employer can actually deduct the liquidated damages. And hence, it may be a breach of contract by the employer if they deducted the LAD without the issuance of a CNC. But as we know, in practice, sometimes, even if when the issuance of the CNC is actually issued, but if the matter goes for arbitration, the arbitrator has the power under the contract or the arbitration agreement to reopen any certificates which has been issued by the SO or the superintendent officer. This include, for example, the arbitrator has the power to say, look, the issuance of the CNC here was actually wrong. You can actually set aside the CNC. So it's actually not all loss for the contractor. The contractor can still challenge the issuance of the CNC in the arbitration process and set aside the CNC. Now, as far as the requirements to apply for EOT is concerned, again, in practice, more often than not, the contractor will fail to comply with the timeline to claim EOT. And the law, unfortunately now, it is actually quite strict. If there is a provision in the contract that the contractor has to apply for EOT within a certain timeline and within a certain procedure or mechanism, it is actually a strict requirement. In the Court of Appeal case of Yueh Tung and in the High Court case of KL Eco City, both the Court of Appeal and the High Court say that based on the wordings of those contracts, in KL Eco City, it was clause 23.1a of the PAM Form 2006, which is similar to the PAM Form 2018. The High Court actually held that this is actually a mandatory condition precedent to any grant of the EOT for the completions of the work. So, and this creates actually problems for the contractors in actual practice. As we know, when the contractors on site, they are rushing for work, then there are actually delays in the work and whatnot. Sometimes the contractor may not actually comply with the 30 days time period to apply for the EOT. And the assessment could have been done, application could have been done beyond the timeline. It could have been done 2 months later or 3 months later. In the meantime, because the contractor was rushing work, the last thing they would do is actually look at the EOT provisions in the contract. And then, more often than not, the SO or the architect will still assess the EOT, even if it was actually beyond the timeline stated in the PAM contract or IAM contract. So if the contractor have submitted the EOT application 2 months down the line, sometimes the architect or the SO will still assess it and say, okay, I grant you EOT, 30 days EOT or 45 days EOT. So what happened in that situation? Does this mean that the employer cannot impose LAD anymore? Unfortunately, the current state of the law is as stated in KL Eco City, and where the High Court, Justice Lim Chong Fong, as he then was, now Court of Appeal judge, sitting in the construction court, held that the SO cannot actually waive the condition precedent set under clause 23.1. Even if the architect or the SO, as the agent of the employer, have actually assessed the EOT, which does not comply with the condition precedent timeline for the submission of the EOT, that EOT is actually not valid. It's actually not valid. So this creates a very serious problem for the contractor, as you can imagine. In a contractor in a situation during the progress of the project, there has been delay, and then they have applied for EOTs, but they didn't comply with the timeline to submit the EOT. SO have actually granted the EOT, and then when a dispute arises later, matter referred to arbitration or to the courts, suddenly the employer can turn around and say, hey, I never give any express authority to the SO to assess this EOT, which was actually submitted out of time. And the court or the arbitrator would say, yeah, this EOT is actually not valid. And then that situation, it may actually be a case where the employer can impose LAD for the delay in the work, notwithstanding the fact that EOT was actually granted during the progress of the work by the SO or the architect. Now, so this is actually a real problem that we are facing now in the construction industry, and there's actually no easy solution. I can see we have two set of problems now between the employer and the contractor. On the part of the employer, the disadvantage that they face now, as we can see just now from the case in the Masurimas, RC Asia, Era Kemuncha and Masurimas, is the fact that if the employer have actually granted EOT, when there's no EOT clause, if the matter is referred to arbitration or to the High Court later, the contractor can turn around to say that I'm not bound by the EOT timeline that you have granted because there's no EOT clause. Instead, time to complete the work has been set at large. I can now complete the work within a reasonable time. And what is a reasonable time is a question of fact, depending on the circumstances of the case. So the contractor may well benefit in that situation when there's no EOT clause and the employer had granted EOT during the progress of the work. So that would be to the disadvantage of the employer, such as the Masurimat case. On the other hand, if we look at the KL Eco City case, it could be a situation where the SO granted the EOT out of time, outside the timeline for the submission, and the employer can now turn around in the court or in the arbitration process to say, hey, all this EOT granted by the SO is out of time. You didn't satisfy the condition precedent as a contractor, and therefore it is not valid. I'm now going to impose LAD on you. So this is a dilemma which is faced by both the contractor and the employer in actual practice now because of the state of the law. And there's no easy solution for now. We have to see how the appellate courts, Court of Appeal, and hopefully the federal court would revisit these issues again and perhaps provide more clarity on the law on this issue. So with that, I would have ended my presentation. Thank you very much. I hand back the floor to the moderator, Ms. So. You are muted, Ms. So.
Thank you, Mr. Wong. We are well within time. We have the next speaker, Miss Karen Ying, to present her topic. Karen, you may start now.
Okay, thank you. Okay. Can you see my slides?
Yes, Karen.
All right, thank you, Miss So. Good evening, everyone. My name is Karen. The topic of my presentation today is wait, there's something wrong with my is liquidated damages still claimable after termination of contract? Have you ever thought of this question before? That if a contractor has been in delay in its progress of the contract, and past the contractual completion date. And what happened after 2 months, the employer terminated the contract. So whether the employer can still impose liquidated damages against the contractor in this circumstance. Okay. There are 3 possible approaches in order to answer this question. Before I proceed further, okay, just to make a note that I refer to this textbook, Law and Practice of Construction Law in Malaysia, where the general editor is Yang Arif, Datuk Lim Chong Fong, and I also refer to the article written by Mr. Wong Hin Loong. Yeah, so the first approach is that the right to impose liquidated damages is lost, including accrued damages. All right. So basically, the employer would not have the right to impose liquidated damages when a contract is terminated. Okay. The second approach, the liquidated damages will be allowed to be imposed until the date of termination of the construction contract. Thereafter, the right to continue such imposition ceases. Okay. So basically, for the second approach is that the employer will still be allowed to impose LAD against the contractor, but only up to the date of termination. The third approach is that the liquidated damages will be allowed to continue until the completion contract, until the completion contractor or the rescue contractor achieves practical completion under the new contract. These 3 possible approaches were highlighted by the English Court of Appeal in this case of Triple Point Technology Inc. and PTT Public Co. Limited. The first approach finds support in the House of Lords case of British Glenstone and General Accident, Fire and Life Assurance Co. Limited. This first approach can be argued to stem from a strict interpretation of the LD clause itself, because it will require a definite starting date and end date for the computation of the amount. This is what have been mentioned by Mr. Wong just now. It's a requirement for an LD clause to be inoperative. So you will require a starting date and an end date. Okay. So for a case where there is a termination, then arguably there's no date from which the LD can run to after termination. Okay, so this could be the reason behind of this first approach. I will now quickly just show you an example of the LAD clause. I think most of you, if not all of you, will be familiar to this clause 22 of PEM contract, damages for non-completion. Yeah, so if the contractor fails to complete the works by the completion date, and the architect is of the opinion that the same ought reasonably so to have been completed, the architect shall issue a certificate of non-completion. Yeah, so this is one of the requirements mentioned by Mr. Wong also just now. This is the condition precedent, okay, under PEM contract. For LAD clause, it depends on the wording of each contract. Okay, for PEM contract, this is the condition precedent that the architect will have to issue a certificate of non-completion. Upon the issuance of the CNC, the contractor shall pay or allow to the employer a sum calculated at the rate stated in the appendix as liquidated damages for the period from the completion date to the date of practical completion. So you can see, I will stop here. So you could see the first approach here. You see, if we interpret the LD clause itself, it will require a definite starting date and end date for the computation of the amount. And because of termination, there's no date from which the LD can run to after termination. The second approach finds support in the case of Reno Port Limited and Technical and General Guarantee Co. Limited. The court in this case held that the claimant was entitled to liquidated damages up to the date of termination and general damages thereafter. In Malaysia, in this case of Kerajaan Malaysia and KCSB Consortium, the court held that therefore the LAD shall be calculated from the date of service of the CNC up to the date of termination. So this is aligned with the second approach. Okay, so what is this third approach? The third approach is as held in this case, Hall and Vander Hayden, where the court held that I reject the suggestion that the defendant's liability to pay liquidated damages somehow came to an end when his employment under the contract was terminated. There is no such provision in the contract. Any such term would reward the defendant for his own default. Take the example of a contractor who has wholly failed to comply with the contract, is in considerable delay, and is facing a notice of termination. The defendant's case would mean that such a contractor was only liable to pay liquidated damages for delay before the decision was taken to terminate, thereby penalizing the employer for trying to get the works completed by another contractor. So as what I mentioned just now, this third approach is it will allow the employer to impose the LAD from the original completion date under the first contract, okay, until the completion contractor, or what we call the rescue contractor, achieves practical completion under the new contract. Okay. Yeah. So this decision was described as questionable in this textbook of Hudson, and arguably, it has also ignored the duty to mitigate and common law claims for the employer, because generally under the general principle of the breach of contract, when a party breach of contract, the principle is that the non-defaulting party will have the duty to mitigate its loss. So for this third approach, it may appear that the employer may not have the duty to mitigate its loss reasonably. Okay. So what was the decision of the English Court of Appeal in this triple point technology? The English Court of Appeal, they followed best of, meaning the first approach. Okay. So when this case went up to Supreme Court, the Supreme Court disagreed with the Court of Appeal. Okay, the Supreme Court was inclined to adopt the second approach. The Supreme Court held that in the event a contract is terminated before works are complete, the LD accrue until the contract is terminated, after which the employer may be entitled to general damages. Okay. So the Supreme Court also held that the difficulty about this approach is that it is inconsistent with commercial reality and the accepted function of liquidated damages. Parties agree to a liquidated damages clause so as to provide a remedy that is predictable and certain for a particular event. In this case, is the delay in completion. This is the event. Okay. The employer does not then have to quantify its loss, which may be difficult and time-consuming. So these are the reasons behind the decision arrived by the Supreme Court in this case. This second approach also finds support in the Singapore Court of Appeal case of Diamond Glass Enterprise and Zhongkai Construction. The Singapore Court of Appeal held that the obligation to pay LD will survive, LD liquidated damages will survive the termination of a contract, but that liability for LD stops accruing on the termination date. Primary obligations of a contract will come to an end upon termination. In other words, if the employer incur further losses due to delays to a project after date of termination, the employer will need to claim its actual losses as general damages. So what about in Malaysia? In Malaysia, this second approach also adopted by these two cases. Okay? In the case of KL Eco-City and Taxing Engineering and Construction, the High Court referred to triple point technology, the Supreme Court case of triple point technology, and held as follows. In the premises and based on the certificates of EOT number 1 and 2 and the CNC, I find and hold that KLE imposition of LAD for delayed completion from the extended completion date to the termination of the contract is hence lawful. Okay, so this is the second approach. And what about in this case of China Construction Pearl River and Industrial and Commercial Bank of China? Just a bit of brief facts here. The plaintiff was the main contractor under the contract, whereas the second defendant was the developer under the contract. So in this case, the plaintiff's employment under the construction contract was determined by the second defendant before the original completion date expired. So this case is different in the sense that the termination happened before the original completion date expired. Okay, the plaintiff's contractual entitlement to EOT has not been taken into account. So when the defendant counterclaimed for the LAD, the High Court was of the view that the defendant's LAD claim was premature and wholly speculative because the plaintiff's contractual entitlement to EOT has not been taken into account, and also because the termination happened before the original completion date expired. even if the High Court also further held that even if the plaintiff is culpable for the eventual delayed completion, losses of the second defendant has to be proved and assessed by way of general damages. The High Court referred to triple point technology and held that the LED clause probably inoperative by reason of the determination of the employment of the plaintiff. Okay, so the key takeaway here is that absent any special wording, the termination of a contract will generally not affect a claim for delay liquidated damages in respect of the period before termination. However, delay liquidated damages will usually cease accruing at the point of contractual termination. Therefore, if an employer incurs further losses due to delays to a project after the date of termination, the employer will need to claim its actual losses as general damages. Yeah, so I will briefly touch on set-off here. I think most of you also will be familiar of this contractual clause of set-off. It is common in the construction contract, especially all these standard form of contracts. So I will talk about contractual set-off and equitable set-off here. So this provision here that I've cited here is the second part of the LED clause under the PEM form, where it provides that any set-off by the employer shall be recoverable from the contractor as a debt or from any monies due or to become due to the contractor under the contract and or from the performance bond. So in order for the employer, in the event the employer is entitled to impose LED against the contractor, okay, so by way of this express provision here, the employer will have the right to exercise its set-off from any monies due or to become due to the contractor, for instance, under the interim certificates. So for instance, if the employer has the right to impose 500,000 of LED against the contractor, and the architect has issued an interim certificate for 600,000, then the employer rightfully can exercise right of set-off against the payment to be made to the contractor. And here for this clause 22, it also provides for the right to set off from the performance bond. Okay, so for retention sum, usually it is can be used by the employer to set off against any defective works where the contractor failed to rectify, and if the employer has to incur costs, to rectify the defective works of the contractor, and if there is clear wording in the contract to allow the employer to exercise the right of set off, then the employer will be able to exercise it. But just a word of caution that, like for PEM form, you will have to look at the clause 30.4. There is a clause 30.4 for set off where there are some conditions to be met before an employer can exercise the right of set off. Okay, so I won't go into detail on that. So what happened? Is it possible for sometimes it's quite common where under a project there are different packages of contract where the employer will award, say, 2 packages of contract to the same contractor. So whether or not the employer can exercise the right of set off from the monies due or to become due to the contractor under the separate contract, meaning another contract. So it is possible. The answer is that it's when they are express contractual provisions providing for cross set-off. Yeah.
Wrap up your presentation.
Okay, all right, right. Yeah, okay, the other one, last point is equitable set-off. Equitable set-off is where the same situation where there are same employer and same contractor, same parties, right? But there are no express contractual provisions under their contracts, whether or not the employer can exercise this right of set-off. The by way of operation of law is it is possible, provided that the employer can prove the proximity and connection of the parties, for instance, same parties under the same project or same site. Okay, that's all. Thank you.
Thank you, Karen.
Yep.
Last but not least, we have Mr. Goh Chin as our last speaker.
Thank you, Jing Han. Now I will just share screen of my slides. Okay, once again, good evening all. Today I'll be sharing some information in relation to damages for non-completion, except for the LAD part, which is already been covered by the other two speakers. So the big question, what is the purpose of an award of damages? So to put it simply, an award of damages is to compensate the innocent party for its losses due to the defaulting party's breach of contract. So I will now go through what are the common specific heads of loss or damage claimable, especially for employer in the event of non-completion by the contractors. So number one is the additional cost of completing the outstanding works left over by the contractors. So generally, to calculate the additional cost for completing the works is the total cost incurred minus the amount that would have been paid to the contractor for completing the balance work under the contract. However, in the case of LYS Capital Holdings, Sdn Bhd and Louis Ming Sim, the Court of Appeal in this case actually allowed the appellant's claim for additional costs incurred to complete the balance work, even the appellant failed to tender any proof of payment to the third-party subcontractor. One of the points which were to highlight in this case is that because the completed balance work and remedial works in this case was not disputed by the parties in the case, and on this basis, the Court of Appeal allowed the claim for damages even in the absence of proof of payment. Number two, the cost of rectification of defects. This is quite one of the common issue in the event of non-completion. So the usual measure of damages for defective works is the cost of rectifying those defects, provided that the performance and the cost of the rectification works is reasonable in the circumstances. So to test whether the claim for the rectification cost is reasonable or not, we can look at the UK case of Ruxley Electronics and Construction Limited and 4C. And in this case, the defendant had contracted to build a swimming pool for the plaintiff, but the contract stipulated that the deep end of the pool should be 7 feet 6 inches deep, but as constructed, it was only 6 feet deep. So in this case, the plaintiff claimed damages in the sum required to demolish and reconstruct the pool to the specified depth. So the House of Law in this case rejected the plaintiff claim for reinstatement costs on the ground that such costs were out of all proportion to the benefit to be obtained. So, and also the court held that the pool was held to be perfectly safe to dive in. So in the event, if you want to claim for the rectification cost, it has to be reasonable. Number three, overhead costs. In the event of breach by the contractor, the employer is required to work its staff for longer hours at an additional cost, employ additional staff, engage consultants to assist in claims preparation, or otherwise deploy greater resources than it would have been done but for the contractor breach. So the employer will be entitled to recover additional costs, provided that all these claims are sufficiently identifiable and again, reasonable in amount. Number four, loss of profit. The owner, the employer, may also be entitled to recover as a direct loss the profit it would reasonably have expected to earn had the building been completed on time instead of completed late. One of the classic example would be the loss of rent and also loss of production from the building itself. Number five, wasted expenditure. So money reasonably expended by the owner, which it otherwise would not have spent on measures to keep its business functioning in the face of the contractor breach of contract. An owner of a building may be entitled to claim for cost of alternative business premises because the contractor haven't completed the building and therefore I have to rent another business premises to operate my business as a wasted or unnecessary expenses in the event that the contractor fails to complete in time. Number 6, this is one of the common claims in non-completion, is that interest and finance charges. A non-completion by a contractor may lead to an extension in the duration of the project, which in turn may cause the owner to incur additional interest expenses on borrowings and other costs to finance the project, such as an overdraft or an bridging loan. In principle, this additional finance cost is recoverable. These additional finance costs include borrowing by the owner to pay for or to carry out not just remedial works, but also for balance work and associate work matters. So in order to claim for interest or finance charges, the owner must tender sufficient documentary evidence to demonstrate that the interest or finance charges was actually incurred by the owner. In the case of Syarikat Pembina Anggrek Sdn Bhd and Malaysian Airport Holdings Berhad, the High Court held as follows. A claim for finance charges is a claim for special damages and has to be proved specifically by documentary evidence on the actual expenses of financing incurred due to the delay in payment. In order to claim finance charges as special damages, a plaintiff, take note, has to prove document on bank loans and finance facilities taken by the plaintiff, the actual amount of finance charges paid or payable to the bank and or lenders during the relevant period of time. Lastly, I'm going to cover legal costs. The legal costs that a claimant would definitely incur in a legal proceeding against a defendant for damages in respect of the defendant's breach of contract, unfortunately, are irrecoverable as a head of loss or damage, even though the need to bring the legal action may have arisen from the defendant's breach. In the recent case of Golden Star and others, and Ling Pek Ho and another, the Federal Court, in setting aside the decision of the Court of Appeal and High Court on an award of 2.6 million legal fees as part of the special damages, held as follows. As a matter of law, the legal fees, charges, retainer, refractioner, or any other charges associated with the litigation between the parties at the High Court, likewise in Federal Court and Court of Appeal, are not claimable as damages. These sums are only claimable as a cost within the cost regime as provided under Order 59 of the Rules of Court 2012. So generally, how are we going to assess the damages? So when the innocent party claims damages from the defaulting party, he must first establish 2 points: elements of causation, and also to demonstrate that the damages is not too remote. So in the local case of Popular Industry Limited and Eastern Garment Manufacturing Sdn Bhd, the court spoke of the general principle governing damages in these eroded terms, stated that a word about general principle: when a party claims damages from a defendant, he has to show the loss in respect of which he claimed damages was caused by the defendant's wrong, and also the damages are not too remote to be recoverable. So what is causation? It simply means that the damages claimed by the innocent party was caused by the defaulting party's breach of contract. What about remoteness of damages? I believe most of the lawyers were aware of this point. The general principle of remoteness of damages was established in the landmark case of Hadley and Baxendale in the following words: when two parties have made a contract which one of them has broken, the damages which the other party ought to receive in respect of such breach of contract should be such as may be fairly and reasonably considered either arising naturally, i.e. according to the usual course of things from such breach of contract itself, or such as may reasonably be supposed to have been in the contemplation of the parties at the time they made the contract as the probable result of the breach of it. So the principle in the case of Hadley and Baxendale was later codified in our law, Section 74 of the Contracts Act, 1950, which expressly allowed the innocent party to claim for direct damages, i.e. damages arising naturally, that is according to the usual course of thing resulting from the breach, and also consequential losses or special damages that result from the breach and which both parties had in mind when they executed the contract. Secondly, proof. Generally, a party seeking to recover damages is required to prove its actual loss on a balance of probabilities. In the absence of sufficient proof of loss, the innocent party will only be able to recover nominal damages. So please bear in mind, the claims for damages in the event of breach of contract by the contractor is not a blank check issued to the employer. In fact, such claim for damages is governing by certain rules. One of it is the mitigation of damage, which is the rules governing the recovery of damages by the innocent party are subject to the condition that the party cannot recover damages that could have been reasonably mitigated through appropriate steps. In the landmark case of Kepadatan Timber Extraction Co. and Chong Fa Shin, our federal court established that the law imposed a duty, even though not stated in the contract, impose a duty on every person who suffered damages on account of breach of contract to take reasonable steps to mitigate the damage. So, in the case of termination by the employer due to breach of contractor, the employer will have the legal duty to mitigate the effects or consequences of the breach. In other words, the contractor will not be required to bear the full cost of an owner's wanton expenditure post-termination. And generally, mitigation of loss means that where the innocent parties is presented with two or more reasonable and effective options to resolve the breach by the contractor, the innocent party must adopt the cheaper of the two options. Wow, so fast. With that, I end my presentation. Jinghan, back to you.
All right, and thank you. Thank you everyone for, thank you all the speakers for their interesting and excellent presentations. Now I'll see whether we have any questions from the participants. I can see one question here. Can time be set at large even if there is an extension of time clause, but there is an act of prevention by the employer? Mr. Wong, would you like to take this question since you covered this topic just now?
I see. Okay, so this is a very common issues which arises in any construction projects in Malaysia. What happened is that you can have an EOT clause, and then the contractor would actually submit the EOT applications because of the act of prevention by the employer. And then the employer or the SO would either, one, they can fail to access the EOT. They won't access the EOT, you just sit on it. Two, in some situations, they may even tell the contractor, look, I would do a global assessment of the EOT once the CPC is issued or the final certificate is issued. Only then I will assess it. So that is well after the timeline provided in the contract. Or even in situation number 3, the employer or the architect may just say, I reject your EOT, or you apply for 100 days, I only give you 10 days. And there's no valid grounds given by the employer or the architect. So in those type of situations, I think it is quite strike law or settled in Malaysia. We have cases like Namfat Construction, for example, which actually held that, look, when the employer actually failed to assess the EOT, don't assess at all or give inadequate assessment of the EOT. So this can actually be challenged by the contractor in the arbitration or in court, and the time would be actually set at large, which means that the contractor can actually complete the work within a reasonable time based on the facts of the case. So the answer would actually be yes, time can be set at large because of the act of prevention by the employer in failing to assess or inadequate assessment of the EOT. I hope that answers the question. Yeah.
All right. We only have one question from the participant. So if there's no further question from the participant, then I have some questions for the speakers. Chin Hao, just now, one of your slides drew my attention. You cited a court of appeal case which allowed the claim for additional completion costs without payment proof. So my question is this, is payment proof required in claiming damages?
Generally, proof of payment is required for your claim for damages. And one noteworthy point about the case law I cited just now is that the completed remedial works and also the balance work was actually not disputed by the parties in that case. And on that ground itself, the court decided that since work already been completed, so for sure costs would have been incurred by the innocent party. And on that basis, the court allowed the claim for damages. But Jing Han, generally the cases I encounter so far is not on the employer didn't spend the money. If you have incurred the cost to carry out the work, you would have no issue in tendering all the proof of payment to support your claim. And the usual common issue I have encountered is that the employer have not incurred any cost to carry out the works due to either it's too expensive or they cannot afford to carry out the work. So in that scenario, the question would be, usually what they have in their hand is the quotation from a contractor or from another subcontractor to carry out the work. So in that scenario, the question will be whether the quotation holding by the employer itself is a sufficient proof for their damages. So previously, there are some conflicting high court cases on this issue, but all these issues have been settled in by a fairly recent federal court case. I think it's Yueh. The court held that a quotation alone is a sufficient proof for damages. So with the quotation itself, you can actually claim for your losses due to defective works.
I see. Oh, so we have two new questions came in. One of it is related to what Goh has just said, is about the remedial cost damages. Can we support it by quotation? I think Goh has
I have
answered.
answered that now.
Yeah. Okay. And then the next question is, would employer lose the right to claim LAD if CNC is not issued? Any of the speakers would like to answer this question?
I think I more or less covered this in my presentation just now. In general, is that, again, it depends on the wordings in the contract. If the wordings in the contract suggest that the issuance of a CNC is actually a mandatory or condition precedent, is actually a CP, then the employer would actually lose the right to claim LAD if the CNC was actually not issued. It's again depending on the interpretation of the wording in the individual contract. I hope that answers the question.
All right. Okay, we don't have any new question. Oh, well, maybe I have one question for Karen. Karen, just now you talk about the first, second, and third approach, and then in the second approach, you say that the employer can actually claim liquidated damages up to the point of termination, and after termination, the employer can actually claim actual loss. So how does an employer actually prove the actual loss and as general damages?
I would think that it will have to be additional costs that the employer has incurred after the termination. So if the employer is able to prove that it has incurred additional costs on top of the LAD that has been imposed for the period between the completion date up to the termination of contract, then that is the actual loss that the employer has suffered due to the termination of the contract. Yeah. So basically, is accord with the principle of general damages. Yeah.
I see. Do we still have any more questions? No. Oh, okay, then I'll ask more questions to the speakers. Mr. Wong, just now you talk about the condition precedent for extension of time claim. Now we know that now most standard construction contracts would require the contractor to give notice of intention to claim extension of time as a condition precedent. So the question is, can the employer still claim LAD if the contractor fails to comply with the condition precedent?
I think the law, the general approach in Malaysia and in UK, it seems to suggest that it's still possible for the employer to claim LAD. So we can take it step by step. There was an act of prevention by the employer. So it's actually the employer's fault for failing to do something which caused delay in the work. So there was an act of prevention. But then the stage 2 is contractor, however, unfortunately, failed to give a notice to actually ask for AOT within the timeline, for example, 30 days timeline or whatever. So in that situation, the employer would seems to be benefiting from his own breach because he say, hey, your AOT application is not valid out of time, so I'm still going to impose LAD on you. Although it was my act of prevention which prevented you from doing the work on time. So the law seems to suggest that the contractor should not be allowed to actually ignore the contractual notice or provisions. And the time is actually not set at large, and the employer can still actually claim LAD in this situation. The rationale of the court in Malaysia, in the case of Daya CMT, or in UK in Multiplex, for example, it seems to suggest that if we don't interpret the law in this manner, that means that the contractor is actually better off by ignoring the notice requirements. If the contractor don't comply the notice requirements, then actually time is at large. So it seems to be better for the contractor in that situation. And then the court say that no, we must uphold the contractual provision. So if there's a contractual provision and the contractor failed to comply with the timeline to apply for AOT because of the act of prevention by the employer, then in that situation, the employer most likely can still claim LAD. So this is the law, current law now, whether we like it or not, which is actually not to the benefit of the contractor. It's actually not to the benefit of the contractor.
Well, the current law about condition precedent, the notice to give the notice of intention to claim EOT as a condition precedent is very strict now. And if we didn't give the notice, then it's better to the contractor's extension of time claim. Isn't that very unfair, Mr. Wong? Is there anything that we can do to prevent this kind of situation where the contractor cannot claim extension of time when there's obviously delay in the project? Or other speakers, you can share your view.
Karen, Chinao, you want to and any
I would
thoughts
think
on this issue?
at the moment, because the court has adopted the strict interpretation of contract, where this condition precedent has to be met strictly, fulfilled by the contractor, I would think there is no other way but to advise contractor, you see, that their administrator, the contract administrator, or their in-house QS will have to be very alert when there is any delay event, right? Then they have to quickly put in a notice first. At least even if you are not able to assess the impact of the delay events, for instance, how many days that you will require, I mean, because of these delay events that will delay your works, and how many days of extension of time that you require, but at least quickly put in a notice first, you see, to then later at least try to preserve your right to put in a very initial notice first. Then after that, then you can come in with the second notice of the detailed claim. Yeah.
Yeah.
Before we end the session for the CP requirement.
I think Mr. Wong and Karen pretty much cover up all the practical steps already.
All right. Okay, I think we are about to time. Oh, we have one last question from Kelvin Hong and partners. If the delay event is caused by a third party, can the employer impose LED on the contractor? Anyone would like to answer this question?
I think generally the answer should be no. If the delay event, well, you can term it as a neutral event. If it's a neutral event, then of course the employer cannot impose LED. But again, it depends on the issue of who is the third party here. For example, in the Masur Rimas case, for example, the High Court actually held that the contractor was liable for the damage to the marbles in the hotel project, which is actually caused by a trespasser. And this trespasser was possibly the ex-employee of the subcontractor to the contractor. And then the court said this was based on the principle that the main contractor continues to be liable to the employer for the whole of the works, including any defective works or any default committed by subcontractors. So in that situation, it's possible if the third party is actually parked under the subcontractor to the contractor, or in Masur Rimas, a bit unusual. It was not, it was actually an ex-employee of the subcontractor, and yet the court held that, yeah, the contractor was liable, then he should be held liable to pay damages. So that is possible if you look at the Masur Rimas case. Yeah.
Thank you, Mr. Wong. I think our time is up. Ladies and gentlemen, thank you very much for your participation in this talk. I hope you enjoyed the talk. I'll now hand back the floor to Sharifah.
Thank you, Ms. So. And thank you to our panelists, Mr. Wong, Ms. Karen, and Mr. Goh, for joining us today in our edition of Big Talk today. We look forward to hosting you again at our next Big Talk. Thank you, everyone. Please have a good day.
Right. Thank you. Thank you, everyone.
Everyone.
Bye.
Thank you,
Bye-bye.
everyone.